Please, Lordship. Lordship, I beg to mention item 24 of today's list, my lord.
Yes.
Lordship, I am appearing on behalf of D. Upamanyu. Lordship, because of the medical emergency, he cannot appear. So I have informed the.
I am for the petitioner, my lord. My only prayer, my lord. After vacation, immediately after vacation, we
24.
20, item number 24, Lordship.
24.
Yes, Lordship.
As prayed for on the ground of, as prayed for on behalf of Mr.
D. Upamanyu.
D. Upamanyu, Learned Standing Council Health,
Yes, Lordship.
who is said to be indisposed,
Yes, Lordship.
which is not opposed by the other side. List this matter on
immediately after vacation.
after 2 weeks on a date to be fixed by the registry.
Bear, please, your lordship. Item number 27, lordship. I have taken consent from the other side. This matter may come after vacation, lordship.
As prayed for by MS S. Kanun, Learned Counsel, for the petitioner with consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Deeply.
May it please, my lord. I beg for listing an IA, my lord. Your lordship has disposed of this matter, my lord. Some correction.
May I please, Your Lordship? Lordship, I beg to mention item 43 and 44, Your Lordship. In this matter, senior counsel Mr. G. Boysa will lead us. So he is out of station. Because it can be after the
You are
petition.
for?
After the petition.
As prayed for on behalf of the petitioner to the effect that Mr.
G. Boysa.
G. Boysa, Learned Leading Counsel, is out of station, which is not opposed by the other side. List this matter after
Vacation.
2 weeks on a date to be fixed by the registry.
Deeply.
My plea, your lordship. Lordship, item number 9, your lordship. Lordship may not be pleased to take up this matter, your lordship.
9.
Yes, your lordship.
List before any other bench. Without
Oblige, your lordship.
May I
Yes.
please, your lordship? With the consent of other side, I beg to mention item number 13. This matter, we want to withdraw this matter.
Heard MS B. Das, Learned Counsel, for the petitioner. Also heard Mr. S. Datta, Learned Senior Counsel, assisted by MSK K. Bora, Learned Counsels, for respondent number 1 and 2.
Yes.
And anybody else? Stop. Ms. B. Das, Learned Counsel, for the petitioner, submits that she has received instructions from the petitioner to seek withdrawal of the writ petition and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, the writ petition stands dismissed on withdrawal.
Oblige.
May it please, your lordship? Lordship, I beg.
Yes.
Lordship, I beg to mention item number 49. Lordship, in this case, the CGC, they have filed their affidavit in opposition yesterday. So we need 4 weeks time to file a reply, your lordship.
Your name?
P. Hazarika.
As prayed for by MSP Hajarika, Learned Counsel, for the petitioner, list this matter after 2 weeks to enable the petitioner to file rejoinder to the affidavit in opposition filed by
CGC.
CGC. Stop. Let the affidavit filed by the CGC be placed on record by the registry. All right.
May I please, Your Lordship? Lordship, I beg to mention item number 15, madam. That's the response number 4, madam.
1 second, huh? Ujjal. 49 to affidavit conjugal. Yes.
Madam, I beg to mention item number 15, madam.
Item number
15, madam.
15.
Madam.
Yes. What do you want?
Madam, already respondent 4 has filed affidavit, madam. I will allowed to file a reply, madam.
You want to file a reply
Madam.
in item 15.
15, madam.
You are
HP new.
as prayed for by Mr. HP Gwala.
New,
Learned,
madam.
huh?
New.
Learned Counsel, for the petitioner.
Petition.
List this matter after 2 weeks to enable the petitioner to file rejoinder to the counter affidavit filed by the
Respondent 4.
respondent number 4. Okay.
My lord, I am appearing on behalf of the senior, my senior Esbora, Miss Esbora. The item number 4, we do not want to raise, so it may be allowed to withdraw.
Item
the
number
case.
4.
4.
It's a contempt case.
Yes. Petitioner
Who is
got the
there
relief.
for?
Petitioner got the relief.
Petitioner's got the relief. So 4 or 5. Your name?
P. Bora. P. Bora.
Heard Mr. P. Bora,
P. Bora.
on behalf of MS Bora, Learned Counsel, for the petitioner. Stop.
Another item. Item number 12, this matter.
1 second, I haven't passed the order.
Item number 12.
Mr. P. Bora, learned counsel for the petitioner, submits that the order against which the contempt has been filed has already been complied. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this contempt, nothing survives for adjudication in the instant contempt petition. Accordingly, the contempt petition stands closed. Disposed of. Yes. Next.
Next, item number 12, this matter may after Puja vacation.
As prayed for on behalf of MS.S. Bora by Mr. P. Bora, learned counsel for the petitioners with consent.
Yes.
With consent from the other side.
Yes.
With consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Please, Your Lordship. Lordship, with regard to item number 23,
Yes.
that matter may be taken up after Puja vacation, Your Lordship. Pleadings have been completed. Pleadings have been completed, Your
As
Lordship.
prayed for by Mr.
S. Gautam, Your Lordship.
As Gautam, learned counsel for the petitioner with consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry. Yes.
May I please, my also, I beg to mention item number 6. The petitioner has joined his original post and the case has been infructuous.
It become infructuous.
Yes.
Item
Yes,
6 are filed to, sir. Your name?
Partho Pratim R. Chaudhary.
Heard Mr. P.
R.
R.
Chaudhary.
Chaudhary, learned counsel for the petitioner. Health, anyone from health is here? Health?
My lord, I have taken instructions.
Yes, I know. Anybody from health? Madam is there? Also heard MS?
D. Bora.
D. Bora, learned standing counsel, health. Stop. Mr. So, your name?
Partho Pratim R.
Mr.
Chaudhary.
P. R. Chaudhary, learned counsel for the petitioner, submits that the relief claimed in the writ petition has already been.
My lord, he has joined his original post. He was reversed.
Submits that he has received instructions that the petition in the meantime has become infructuous. In view of the aforesaid endorsement made by the learned counsel for the petitioner, writ petition stand dismissed on being infructuous.
Obliged.
My lord, in this matter, my senior tried to contact the petitioner multiple times, but we have not received any reply. As of now, we don't have any instructions.
She has already been terminated, my lord.
Huh?
She has already been terminated.
She's been terminated.
Yes, my lord.
If you have been terminated and it's a matter of transfer,
Yes.
then
But,
matter may have become infructuous.
we got to know.
You have the termination. Please give. Your name?
N. Ahmed.
Heard MS?
N. Ahmed.
N. Ahmed, learned counsel for the petitioner. Stop. Also heard MS?
A. Bora
A. Bora,
for NHM.
learned counsel for
NHM.
NHM. This is item 1, right? Health is also shown. Health is there. And MS so-and-so, learned standing counsel health. Stop. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking setting aside of the order dated 10/11/2023 passed by the Mission Director, National Health Mission, Assam, as well as transfer order dated 28/10/2022 issued by the Mission Director, National Health Mission, Assam. Stop. Today, when the matter is called, MS
A. Bora.
A. Bora, learned standing counsel, NHM, submits that that pending disposal of this writ petition, the services of the petitioner has been terminated by order dated 23/9/2024.
Yes,
They are same.
yes.
Ekhan, did you have some? By speaking order, huh? By speaking order dated, is it 23/9/24? Just check. So and so.
Yes, ma'am.
So and so. She accordingly furnishes a copy of the aforesaid speaking order, which is kept on record and marked as X. In view of the aforesaid endorsement made by the learned counsel, learned standing counsel NHM, nothing survives for adjudication in this writ petition. Accordingly, the writ petition stands dismissed on being infructuous. It'll mark for it.
May
Disposed of. One is disposed of.
Kindly bus of what I'm paying.
Item number?
2, 3 and 5 Lordship.
Yes, it's not actually what you
2, 3 and 5 after
Yes.
some time Lordship. Mr.
Huh?
Mozumdar is on the way after some time. 2, 3 and
Then
5.
it will be called after I finish my admissions. Yes, call out the admission matters. Yes.
May I please, Your Lordship?
Yes, Ms. Bora.
Lordship, the petitioner
Dismissal
was...
from service.
Yes, Lordship. The petitioner was working as a state coordinator of family planning under NSIA, Lordship, National Health Mission. She was terminated from her service on 6/12/2018. That is...
You want to say something?
No.
6?
6/12/2018 on the ground of the unauthorized leave by the petitioner. That is, Lordship, the order is at page 23, Annexure 5, termination order.
Page?
Page 23, Annexure 5.
Yes.
May I read, Lordship?
Yes, please.
Seen and peruse the reply of MS Shamima Khatun, the State Family Planning Coordinator, NHM, State Headquarters, and whereas she has been to be found to be unauthorized absent in duty, which seriously hampered the implementation of the family planning program in the state, and whereas she was reported to be on leave from office during 2017-18 for more than 15 days in excess of her due leave as per the terms of contract, which is violated the clause 9 of the terms of contract, and hence in view of the above and in accordance to the TOR, the contract of MS Shamima Khatun as SFPC stands hereby terminated as per clause 9 and clause 10 of the TOR.
All right. Then what happened?
Lordship, what happened? Actually, petitioner was...
You are challenging this order.
Yes, Lordship.
So what is your ground of challenge?
Lordship, during that period, before the termination order, Lordship, one show cause was issued to the petitioner. That show cause is at page 26, asking the cause of her absence.
Page 26?
Page 26.
Yes.
Dated 24?
Yes, I have it. Please read.
Lordship, the petitioner has submitted her reply, Lordship, that is page 27.
Reply is at page?
Page 27. The reply she sent through mail, Lordship, because she was ill during that period. She was hospitalized. Lordship, may I read the reply?
Yes.
Respected sir, this is in reference to the notice served to me for unauthorized absence from my duty received on 27 September 2018. I would like to state that I have been suffering from abdominal, uterine bleeding and abdominal pain since 11th May 2018. I was under treatment and under Dr. So at Jewel Hospital, Mumbai, and Dr. Pooja Dewan at Kukilaben Dhirubhai Ambani Hospital, Mumbai, and not in the state of fitness to communicate after the expiry of my leave
But
period.
she could have always sent a communication or an information through someone from her family members. You see, it is it is very unbeing of a employee to overstay the leave period. I can understand the ground. Undoubtedly, the ground is there, but that doesn't absolve the person to not to communicate. Family members are there. Somebody could have informed. And this is a matter of So your basic ground of challenge is that you have informed and it is not considered, Ms. Bora.
Yes, yes.
That is the ground.
Yes.
How
Lord-
can that be taken into account by this court under 226?
Yes, but Lordship, during my hospitalization, I was without any attendance.
Have you said that in your pleadings?
Lordship,
Which paragraph? Which paragraph?
Lordship.
And that is not there in this annexure at page 27. Have you
Yes,
said in annexure page to your reply that there was no one? An inquiry was held?
No, Lordship.
Yes.
We have filed our affidavit in opposition, my lord.
Where is it? Ms. Bora, you find out that paragraph?
Lordship.
I'm just having a look at the affidavit. Yes. Which your affidavit in opposition?
Yes, my lord. Filed on 23rd.
Yes. Which paragraph?
At page 6, my lord. We have written and 8.
Page 6.
Page 2, my lord. Paragraph 6. Paragraph 6, my lord.
Yes.
That as on
Contractual basis.
Yes, my lord. As per the terms of contract, NHM employees are entitled for a maximum of 30 days of casual leaves and 6 days of sick leave in a financial year, my lord. That has been given in page 3, my lord. In case of illness, the party obliged to inform the mission director immediately. If the illness lasts for more than 3 days, a medical certificate must be produced. No more than 6 sickness days will be recognized during the financial year. The casual leave and sickness leave are over and above the holidays declared as per the Government of Assam. The terms of reference, my lord, does not provide any leave without pay, my lord, which is in page number 21 of the writ petition, my lord. And
Yes, there is a detailed affidavit, Ms. Bora.
Lordship.
There is a detailed affidavit. They have explained.
Yes, Lordship.
Their rules are there. It does not permit more than 6 days in one financial year. Then I don't find any merit. Where is a reply to paragraph 6 of the AO?
Lordship.
See, in paragraph 9 AO, the authorities have taken the same ground which I have just asked you.
Lordship, that's
It says there is no justifiable reason as to why she could not communicate her status to the authorities either through email or otherwise WhatsApp or SMS while undergoing treatment at Mumbai. This is unacceptable. I have full empathy with the concerned employee, but that does not absolve her for not informing the authorities. Even if she cannot, her family members could have. When she could go to Mumbai and she could avail the treatment, why she could not send a message to the authorities?
Lordship, that reason I have stated at paragraph 9 of my writ petition, Lordship.
And that is why in reply, in the AO, they have dealt with that. They are saying, as stated in paragraph 10(1) of the writ petition, the petitioner did not mention any brief or details of medical treatment or place she would be visiting in course her applied medical leave. The petitioner in her submission stated that she managed her medical treatment and admission in Mumbai without any attendant.
Lordship.
There is no justifiable reason. as to why she could not communicate her status to the authorities either through email or otherwise, WhatsApp or SMS. This is why I'm saying if she could manage her treatment all by herself, what prevented her from sending an SMS or an WhatsApp or an email? All that she was required to do is that I am unwell and I am availing treatment. That could have absolved her. That also is not being done.
Lordship, that reason I have stated at paragraph 9, Lordship.
Of
my writ petition, page 7, paragraph 9. Paragraph 9, Lordship. Sorry, 10.
Paragraph 9.
10, Lordship, it's 10. That with regard to the allegations, the petitioner state as follows: that on 4th August 18 to 18th August 18, the petitioner was on leave on medical ground due to her operation at Kukilaban Hospital, Mumbai, which was duly approved by the authority. Thereafter, due to critical health condition of the petitioner, her treatment and surgery was going on till 28 September 2018 at Mumbai. In this regard, the petitioner informed the said fact to the authority over telephone, and as she was not in a condition to communicate about the extension of her treatment in written form because of her serious health condition, it may be mentioned herein that the petitioner was admitted.
Yes, this is the reply I read. In the affidavit in opposition, that was the reply.
Let's see what I'm submitting, that although in my mail it was not explained, but I was in a regular communication over telephone.
But that they don't admit.
That's
They don't admit that. If you could have, this happened in 2018. In today's time, what is the best mode of communication? What is the best mode of communication, Ms. Bora? Please tell the court. WhatsApp, SMS.
Let's see.
She could have given that.
Yes.
Then that would have been a part of these pleadings.
Let's see.
Yes or no?
Yes,
That is not there.
Yes,
This is why I am saying it's not inspiring confidence of this court, because you see, all by herself she is availing treatment at Bombay. That is also doubtful, but anyway, even assuming that is correct,
yes, that I understand.
and if she could have made a telephone call, what prevented her from sending a SMS or an WhatsApp?
Yes, Lordship. That could have been part of the.
That would have been part of this petition today. And it is very natural. Any employee, first thing he would have done is send a WhatsApp or an email, because that would have some record. A telephone call. In 2018.
Yes, Lordship, I understood. I am told by the petitioner that 2 months of salary was not, which was due to me, that have not released. Lordship. At best, that salary may be released by the respondent on the earlier occasion.
But that's not part of your prayer. Anything due?
2 months salary. Lordship.
Anything due?
No, my lord.
If I can I can dispose of this by.
Petitioner was already paid 1 month remuneration in lieu of 1 month's notice period as per clause 10 of the terms of the contract.
So everything is, which is, where are you reading that from?
Let's say communication.
Explain to one I meant to. Explain to one. Lordship,
yes.
On 38/2023, they have also admitted the 2 months salary before her termination, Lordship. Yes, sir. Delay nahi kiya.
এখন মই 2300 টাকা দিছে তাতে 1 month salary মানে notice period
In fact, there is already an order of this court on 38/2023 that the concerned respondent authority shall release the same. So I am not allowing, I'm going to dismiss this writ petition, but I will clarify that the order of 38 should be complied.
Yes.
If any due are there, that should be paid. All right. Heard MS M. Bora, Learned Counsel for the petitioner. Stop. Also heard MS
A. Bora,
A. Bora, Learned Counsel for the
National Health Mission.
Learned Standing Counsel, National Health Mission within bracket NHM. Stop. By way of this writ petition under Article 2 to 6 of the Constitution of India, comma, the petitioner is assailing the order dated 6/12/2018 issued by the Executive Director NHM Assam, whereby the services of the petitioner was terminated. Stop. The facts of the case in brief is that the petitioner was working as state coordinator of family planning under NHM Assam on contractual basis. Stop. The petitioner, in connection to her treatment at Mumbai, had taken leave. However, she overstayed the leave, correct? For which ultimately her services was terminated on 6/12/2018 by the authorities. Stop. Situated thus, the present petition has been filed. Stop. MS Mbora, Learned Counsel for the petitioner, submits that in view of the fact that the petitioner was in view of the fact that the petitioner had undergone a critical health treatment and surgery at Mumbai, comma, she had to overstay at Mumbai, though the said fact was communicated over telephone. However, no written communication could be given to the authorities as she was undergoing treatment all by herself at Mumbai. Stop. Per contra, MS so-and-so, Learned Standing Counsel NHM, submits that there is no justifiable reason as to why the petitioner could not communicate her status to the authorities, either through email or otherwise, within bracket WhatsApp or SMS, etc., while undergoing treatment at Mumbai as claimed. Stop. I have given my prudent consideration to the arguments made and peruse the material available on record. Stop. Next para. The issue which falls for determination in this writ petition is where is that impugned order?
Lordship, it is at page 26. Sorry, Lordship.
23.
23.
Is whether.
Page 23.
Yes, I got it. Is not, don't say is whether, is the legality and validity of the termination order dated 6/12/2018. Stop. Apt to refer to the termination order dated 6/12/2018 at the outset, which is reproduced hereunder for ready reference. Tomorrow A to A, page 23 of the writ petition. Mark page 23. I'm writing A in the flag. Apparent that the services of the petitioner was terminated in terms of clause 9 and clause 10 of terms of contract in view of the fact that she overstayed her leave in excess in violation of the aforesaid terms and conditions. Stop. Pertinent that prior to the issuance of the termination, impugned termination order, comma, a show cause notice was issued to the petitioner
Page 26.
page
26. 24/9.
yes for showing cause as why her services should not be terminated. For excess stay of leave granted. Stop. In response to the aforesaid show cause notice, comma, the petitioner by email dated 3/10/2018 informed the authorities that due to her treatment at Kokilaben Dhirubhai Ambani Hospital, Mumbai, and she being not in the state of fitness of communication after the expiry of her leave period from 4th to 18th August 2018, comma, she could not inform the authorities. Stop. Apt to reproduce the aforesaid reply hereunder for ready reference. B2B, page 27. Okay.
Lordship, prior to this reply, Lordship, the petitioner has communicated through email to the authority on 27th September also, that is page 24, Lordship.
Page
24, after the show cause notice.
Page
24.
September 27. This is before the show cause notice.
Lordship. No, not after the show cause notice, Lordship.
After show cause notice, she applied for medical leave.
Lordship.
But that is of no relevance because by then you've already overstayed your leave for which you have got your show cause. This what you have done on September 27, you could have done at that time. Are you following what I am saying, Ms.
Yes, yes,
Bora?
Your Lordship.
Stop. The state authorities. No, before that. Apt also to refer to paragraph 10 of the writ petition, which is reproduced hereunder for ready reference. C2C, page 7. Huh? Itu Papa, page 9 or like, page 10 or like. Okay. Apparent that the only ground for non-communicating non-communication and non-seeking extension of her leave is due to the medical treatment that she was availing at Mumbai without any attendant. Stop. However, it appears that though later on the petitioner has communicated to the, where is that? Just now you showed me that page.
Lordship, page 24.
Pranab. Later on, the petitioner, after receiving the show cause notice dated 24/9/2018 by email dated 27/9/2018, applied for medical leave. Stop. Apt also to refer to paragraph 6 of the affidavit in opposition filed by the respondent number 3 on 23/1/2019, which is reproduced hereunder for ready reference. D, page 652 D 52, running page 52, paragraph 6, 8, 9. Okay, 7 to nalaga. It is .7 koi diya. Stop. Reading of the aforesaid pleadings, apparent that though the petitioner could have communicated her status to the authorities either through email or otherwise, within bracket WhatsApp or SMS, while undergoing treatment in Mumbai, she has not done so. Stop. However, upon receiving the show cause notice, she had immediately, within 3 days, 24, 25, 20, within 3 days, replied by email seeking extension of leave. Be that as it may, the termination order appears to be in conformity with the terms and conditions of the contract, and accordingly, this court finds no merit in the writ petition. As such, the writ petition stands dismissed. It is needless to be clarified that this court, by order dated 38/2023, had directed the concerned respondent authorities to release the salaries of the petitioner for 2 months, which is said to have been pending before issuance of the termination order. Stop. If the same is still pending, the respondents are directed to release the same within a period of 1 month from today.
Lordship, there
Sorry.
was an- Lordship, there was an interim order that may be.
Interim order, if any, stands vacated.
The Lordship, calling also Mr. GN Sahewala is on legs.
All right.
Can you take it?
Time being.
Yes, Lordship.
But I'm not sure because today there's one part heard which which will take some time, and then there is another part heard which is also fixed at 2. Do you want to do it after the vacation?
Lordship, can I ask Miss?
All right. Yes. Yes, Mr. Borbuya.
May I please, Your Lordship? My Lord, basically, my Lord, we are paying for enforcement of an order passed by this honorable court, my Lord.
Enforcement.
Yes, my Lord, because
Why? What is the need for you to come before this court seeking enforcement of this court's order?
yes, my Lord.
Why is the government not enforcing the orders of this court?
Yes, my Lord. This is
What
the
is
problem.
which is an order?
Lordship, this order was passed, my Lord, page 20. Thereby, it was provided to consider my representation. My contention was that, my Lord, I am the sole candidate for this post, eligible candidate. And
where is the operating part?
Operating part, my Lord, page 21. Last, my Lord, 5.5 line, my Lord. The representation dated 22/9/2023.
Yes, the
has
representation has been disposed or not disposed?
disposed of, my Lord.
Then why are you saying enforcement?
Yes, my Lord. This representation was, my Lord, disposed of by order at page 26 Annexure 6.
You are challenging the disposal order today.
No, my Lord. It is in my favor, my Lord, because in pursuance to the contempt, my Lord, proceeding, this order was passed, my Lord. And
Page 26.
Yes, my Lord. Then, my Lord, my contempt proceeding was, my Lord, closed in view of that, my Lord, speaking order at page 32.
No, what is this order at page 26?
26, my Lord, it is held that, my Lord, that candidate, my Lord, disputed candidate is, my Lord, not local, and humble petitioner before your Lordship is local candidate, my Lord. Because
so this is in your favor.
In my favor, my Lord. But this was
Directing the CW child. কি হয়েছে এটা? এইখানে ভাইব্রেট করে বন্ধ করে দে তো. But how can you function with the sound? It's irritating. বন্ধ করে দে, এটা কেন কাম করবে? Yes, I have some light. Can you read?
Yes, sir.
You can read, right?
Yes, sir.
Yes.
Page 26 order, my Lord.
No, page 27, it says representation in question is disposed of, directing child development project officer to take necessary step in consultation with project level selection committee in the light of the above observation.
My Lord, they, my Lord, supposed to issue appointment letter in pursuance to this order, my Lord.
Which they did not.
That did not, my Lord.
Then,
my Lord, in view of that order, page 32 order, my Lord, contempt proceeding was closed, my Lord.
Ms. Talukdar, you have the.
We have filed our affidavit, Lordship.
Yes, then.
Then, my Lord, they have, my Lord, instead of appointing me, my Lord, they have issued fresh advertisement, my Lord.
Why is that done, Mr. Talukdar?
Lordship, kindly come to my affidavit, Lordship.
Yes.
Filed by respond number 5.
Yes.
Point number 4, Lordship, running page number 52.
One second. Yes, 52.
52, Lordship. Running page number 52.
Yes.
May I read, Lordship?
Yes, please.
That with regards to the statement made in paragraph 5, the answering department begs to state that as per the order of the Honorable Court by WPC number so-and-so, the Deputy Commissioner Kasar by its letter number so-and-so dated Silchar 8 September 2015, dispose of the representation of the petitioner by directing the CDPO Binakandi ICDS project, Kachar, to take necessary steps in consultation with the project level selection committee. The CDPO Binakandi accordingly moved the Dan District Social Welfare Officer cum Chairman, Project Level Selection Committee, who advised for fresh advertisement, Lordship, because there was no eligible candidate, Lordship.
No, but you see, this representation was disposed of directing the CDPO to take necessary steps in consultation with project level selection committee in view of the observations made therein. Now, what was those observations? Let's come back to those observations at page 26. Now, you read page 26, please. In pursuance, the second paragraph. Let's see what is the observation.
In pursuance of the court's order, the representation stated above has been examined and taken into consideration, and Circle Officer Lakhimpur Revenue Circle Lakhimpur Kachar wide communication dated so-and-so addressed to the sub-divisional officers Lakhimpur Kachar submitted report on residential status of the Lalimia Mojumdar Begum. As per the aforesaid report dated so-and-so, Srimati Lalimia Begum Mojumdar is residing at Singarban Part 3, which does not come under the surveyed demarcated area of the AWC number 110, Singarban Part 2. And the state report also indicates that before and after survey and demarcation in 2014, the residence of Srimati Lalimia Begum
So,
Majumdar.
the representation of the petitioner was as regards the the private
residential status of the
private respondent,
Lordship.
and that you have agreed.
Lordship.
Now, in that case, the petitioner was available.
Lordship, the petitioner was not eligible, Lordship, because
Where have you said that? Because paragraph 4 doesn't talk about the non-eligibility of the petitioner. Which part? Mr. Borboya, you have not filed a rejoinder to this affidavit.
My lord, I have found nothing, my lord, in their affidavit, my lord.
Lordship, regarding the
Where have you said petitioner is not eligible? Have they said that?
No, Lord.
You have to
Lordship,
clarify that stand. Is it there? See,
Lordship.
paragraph 4 says that there is it's a very vague kind of averment.
Lordship, there is no direction that the petitioner should be appointed, Lordship.
This counsel, petitioner had come up with a representation pointing out that the private respondent is not qualified. The court says you examine. Very well, you have examined. Now, thereafter, when you are considering, either you consider it in a proper manner, which case, if the petitioner is there, that case should have been considered. Now, you, in this para 4, you said that because no one else is, it simply says that accordingly move the district so-and-so who advised for fresh advertisement. Now, what was the reason for fresh advertisement? All these are not part of your affidavit.
Lordship, point number 6, Lordship, the next point of my affidavit, Lordship, page 52.
As no suitable candidates available.
Lordship.
Now, why? What about the petitioner? Petitioner is not suitable.
Lordship.
On what ground?
Lordship, that is not clearly written, Lordship.
Correct. That is what this. You see, now you are
regarding
before
the
the court.
educational qualification, Lordship.
Whatever be it, but you must say it.
Lordship.
So you file an additional affidavit
Lordship.
and you clarify your stand.
Lordship.
Let them clarify their stand.
Actually, my learned friend is trying to submit before your lordship is that, my lord. Now, my lord, my lord, this educational qualification is increased from, my lord.
See, Mr. Borbuya, whatever be it, unless those pleadings are made before this court,
Yes,
unless you rebut, how will this court proceed?
Yes, my lord.
MS
A. Talukdar,
A.
Lordship.
Talukdar, learned Government Ad Council for State, is allowed to file an additional affidavit to clarify the status as regards the suitability of the petitioner to the subject post.
In the meantime, they can also file their resign, their Lordship.
You file a detailed one,
Lordship.
My lord.
list after 3 weeks on a date to be fixed by the registry.
My lord.
Deeply obliged, Lordship.
Obliged.
Yes, yes.
May I please the Lordship? Lordship, kindly pass over the matter for today.
For today,
For today, Lordship. Lordship, my senior is not well today.
who's your senior?
P. Mahanta.
MS P. Saharia.
C. Sharma. C. Sharma.
Yes, C. Sharma. MSC Sharma, learned counsel for the petitioner submits that Mr. P. Mahanta, the arguing counsel, is unwell today, and accordingly seeks accommodation in the matter. Prayer is allowed. List after 3 weeks.
No matter otherwise is infructuous, my lord.
Infructuous.
Has to be
Why?
closed. No, subsequent writ petition has been already been dismissed.
Lordship, I am not aware. I have,
I have the
recently-
judgment also.
So, this is the same list.
Same petitioner, my lord. What they challenged initially, my lord, in the matter before my lordship today, the prayer is with regard to a recruitment of 2018 carried out by the APDCL, my lord. Now, their prayer here is to be allowed to participate in the written examination, which they did. Now, subsequently, thereto, my lord, they had challenged the select list that was published pursuant to the recruitment process. Now, that writ petition is the order that I passed. Now, that writ petition has been dismissed now. So, this
No.
has become infructuous.
This is WPC 1132 is where the merit list was
Yes, my lord. Yes, yes.
challenged,
Yes, my lord.
and that merit that is dismissed.
Yes.
And in this,
The prayer is for the petitioners to be allowed to participate in the written examination. my lord.
so but if that list is already dismissed, then there is no question of.
Yes, yes. And in on the strength of certain interim orders, they had actually participated in the written examination.
Infructuous then. Look at it there. Heard MS
C. Sharma.
C. Sharma, learned counsel for the petitioner on behalf of Mr. P. Mahanta. Also heard Mr. B. Chaudhary, learned standing counsel, APDCL. Huh? You are in that corner. I suddenly thought I was in some living room. Huh? Yes. What do you want to say?
I'm supporting his statement, Lordship.
I also heard Mr.
CKS Boro.
Huh?
CKS Boro.
CKS Borwa for
Response number 20. Lordship.
respondent 24.
20.
20. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking directions inter alia to publish the name of the petitioner in the final list shortlisted for the written examination to be held on March 2019 for the post of office cum field assistant within bracket experience stroke Sahaya within bracket experience in respect of Silchar Electrical Subdivision 2 under Kachar Electrical Circle, and also to allow the petitioner to sit in the written examination for the said post. Stop. Today, when the matter is called, it is submitted by Mr. B. Chaudhary, Learned Standing Counsel, APDCL, that This is subfiled after this.
Yes, my lords.
Subsequent to the filing of the present writ petition, the petitioner by way of WPC 1132 of 2020 approached this court seeking assailing the provisional merit list of all the 1423 candidates published on 10/2/2020 under the authority of respondent number 3 for the subject post on the basis of OMR based examination. Stop. This court, by order dated 12/12/2023, dismissed the said writ petition.
It was actually closed, my lords.
Sorry, closed the said writ petition with liberty to the petitioner to take recourse of the remedy as envisaged in the direction issued by this court under the direction number 6 of order dated 27/8/2019, passed in WPC number 2643 of 2019. Stop. The relevant portions will be from 10.
From my lords, if directions are, my lords.
10.
Yes, my lords. Yes.
10 or 5. What is this 5? 5 is, I'll reproduce para 5.
Yes, para 5.
Para 5, 10, 11 and 12 of the aforesaid judgment is reproduced herein for ready reference.
Yes. Para 3 also may be relevant, my lords. It refers to the present petition, my lords. Before my lords.
Stop. Apparent reading from the above paragraphs that in view of the aforesaid judgment passed by this court in WPC 1132 of 2020, nothing further survives for adjudication in the present writ petition. Accordingly, the writ petition stands dismissed on being infructuous.
I'm deeply aware.
Disposed of.
Your Lordship, can it be taken after vacation?
All right. Item 8.
Item 8.
As prayed for by the, you're for petitioner or respondent?
Respondent, Your Lordship.
As prayed for by the respondent, on behalf of Mr. J.N. Sahawala,
Standing Council.
Learned Standing Council
For ASTC.
ASDC,
ASTC.
list this matter after 2 weeks on a date to be fixed by the registrar.
Much obliged.
My lord, in this case, my lord, while
Mr.
I have
Goswami,
Lordship, have to file the affidavit, Lordship. I sent the letter, but yet received the instruction, Lordship. Therefore, kindly fix the matter.
my lord, my submission, my lord, 2 orders, my lord, in the year 2021.
Mr.
and
J.K.
23.
Goswami submits that he has received instructions.
No, not received, Lordship. I sent the letter, Lordship, yet to receive the instruction.
He submits that instruction is awaited for filing the counter affidavit. Stop. The matter pertaining to the year 2019, a last chance is given to the respondent to file the return in the matter, failing which the matter shall be proceeded in accordance with law. List after 3 weeks on a date to be fixed by the registry.
Lordship, can it be 4 weeks, Lordship? Because I have to receive the instruction, and after
Okay,
that, I have to.
Since 2021, there was order of this order.
All right, next matter.
I
My lord,
will
I'm
only
just-
1 week, Lordship.
But you see, I'm making it a last chance, so 4 weeks. There is a Puja is there. Let Mr. Goswami enjoy the puja also.
A date may fix.
All right, we'll come. Next.
My lord, here I pray for some more time, my lord. We have received instruction.
You have received?
Yes, my lord. But the last order, we are directed to file an additional affidavit, my lord. We have received instruction.
You have received the instruction. Mr.
S.K. Chakravarti.
Mr. S.K. Chakravarti, learned counsel for the respondent, learned standing counsel FCI, submits that he has received the instructions as called for by this court by order dated 24/7/2024, and accordingly seeks accommodation to file the additional affidavit as directed earlier by this court. Stop. Prayer is allowed. List after 3 weeks on a date to be fixed by the registry. Yes, 4 weeks time was given for filing affidavit in 2022.
Lordship,
Now we are in 2020.
Lordship,
Oh.
we have received the instruction, Your Lordship, but latest instruction is not
Not
received,
adequate. Very
Lordship.
sad.
Lordship,
Very sad state of affairs.
Lordship, this
2
matter is-
years.
Lordship, additional
2 years you have received instructions which is not adequate.
Lordship, but Mr. K. Kaur, additional AG will appear, supposed to appear in this matter, Lordship, but he is out of station, Your Lordship.
No, what is there is nothing to do with Mr. Kaur. You are saying instructions has come, same is not
Lordship,
adequate.
But Lordship, the instruction is in the year of 2023, Your Lordship.
So from 23 to
So,
24,
up-to-date
what has
instruction-
happened? Why
Lordship-
further instructions has not come?
Up-to-date instruction is not received, Your Lordship.
No, but have you sent communications or not?
Lordship, we have communicated, Lordship.
You have to follow it up.
Lordship,
Yes,
kindly-
last chance.
Lordship,
As prayed for by MS,
J. Bora, Lordship.
J. Bora, a last chance is given to file the return in the matter.
Lordship.
List after 3 weeks on a date to be fixed by the registry.
Obviously.
In this matter
Yes.
also, the department is yet to file. their
Yes,
affidavit.
department 21 matter.
It's a case of pensionary benefit. Petitioner retired around 3 years back.
You have
And-
not got any pension?
No, pension we have not got, and during his service period, Lordship, he worked as a work charge employee, and after rendering for more than 23 years, his services was yet to be regularized. No pension paid till date.
Achha, this is because of that. Yes, affidavits.
Because I have received instruction, but
The instruction
not
is not good because the instruction is neither filed nor placed before this court, and top of it, you are saying it is not adequate. This is a matter of 21.
Last chance may given, I will place it.
Very unfortunate. One must show some compassion also.
This is
These are matters which cannot be delayed.
I will
There is no point of placing that instruction which you have already said is not adequate before this court. What is this court going to do with an incomplete instruction? How much time do you need for final?
After vacation, my lord.
But this is going to be your last chance.
My lord.
Your name?
M. Das.
MS M. Das, Leonard.
PWD.
Standing Counsel. Standing Counsel, PWD submits that though instructions have been received in the matter, however, the same is not adequate enough to file the return. Stop. She accordingly seeks accommodation in the matter. Prayer is allowed. It is needless to be clarified that if the return is not submitted by the next date of listing, adverse orders, including orders for personal appearance, if necessary, shall be passed in the matter. List after 3 weeks on a date to be fixed by the registry.
I am paying for 6 minutes.
Date be given, Lordship. There is some urgency.
It's all right. It will come. I'm not putting all your appearance. Your names are all there. Yes.
May I please also?
Yes. You want to file a rejoinder?
Lordship, I may be allowed to withdraw this petition.
Withdraw. Your name?
UK Decker.
Heard Mr. UK Deka, Learned Counsel for the petitioner. Stop. Also heard Mr. G. Bordoloi, Learned Counsel, Learned Standing Counsel, Cooperative Corporation Department. Stop. Mr. Deka, Learned Counsel for the petitioner, submits that he has received instructions from the client to seek withdrawal of the writ petition, and accordingly he makes an endorsement to the same effect. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, the writ petition stands dismissed on withdrawal.
Obliged.
Disposed of the 19. Yes. None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registry. Yes, rejoinder. Rejoinder. You have taken time.
Not filed, my lord.
Have you filed?
No, my lord, I have not
So
filed.
how much more time?
My lord, the petitioner is having some difficulty, so she could not come, my lord.
All
So,
right.
my lord, today may I pray, my lord, maybe dispose of my lord without.
There is a judicial order.
My lord.
You have sought time, and you are saying petitioner
Actually,
could not come for filing. It's all right. You take your
Now-
time.
Now I have been instructed. She is having some problem. That is why, my
So
lord.
very well. I'm posting it after vacation.
My lord.
As prayed for by Mr. C. Talukdar, learned counsel saw for the petitioner that the rejoinder as required to be filed could not be filed due to health reason of the petitioner, and accordingly seeks further accommodation. Stop. Prayer allowed. List after 3 weeks on a date to be fixed by the registry. Bless you, Lord. Yes, Mr. Chalia.
Yes, Lord. Lord, this is a case where the appointment, some changes made in the appointment order.
Yes.
Although in 2006, 2008, I'm sorry, Lord, at page 19,
Page
Lord, you'll
19.
find an advertisement was made for appointment of ASA supervisors throughout the sum. And the criteria for appointment was
Yes. 19. Where is the translated copy?
Hi. I'm sorry. It is.
Yes, I have got it.
Yes. Next page. Their appointment for officer supervisors and the
Appointment is, what is appointment on ASHA supervisor?
ASA supervisor. It is not in the Panchayat mirror. Just
And
above
what is the
ASAs.
post? Huh?
ASA centers are there, so just above that, and in every center out of 20, out of 10, there has to be 2 supervisors.
All right. So
And
this is for
accordingly-
the post of supervisor.
Post of supervisors.
This is now again every 10 ASA 1 supervisor.
Yes.
Correct?
Yes.
Yes.
Now, although the application was invited in 2008, Milord, as your lordship has
You
seen.
don't wish to file a rejoinder?
No. It is simple case, Milord.
All right.
Because in this selection was made during that period only, but due to some court cases, appointments during in that center could not be held. One particular center, Milord, it is
which center?
Gajari Kandi.
Huh?
Gajari Kandi.
Gajari Kandi.
Gajari Kandi. It is in Dhubri. Gajari Kandi.
GA.
Dhubri.
Dhubri.
So in respect of one center, it could not be appointment
Selections were made, and that was challenged before the honorable court.
Appointment, that's why it could not be made.
Could not be made. There were 2 series of cases, and finally in 17, this selections process was continued, and during that period, Milord, a new guideline has been issued by the department, where there were out of amongst 20, there will be 2.
21. One
No,
is to
now
two.
it is 1. Previously it was 20. In 20, it is 2. So totally half portion has been cut out, and now they have appointed. I have challenged the appointment, Milord. They have appointed
But that will you are in you had applied pursuant to the earlier advertisement.
Yes.
So,
So-
how can the new guidelines
Yes, that
be
is my point,
applicable
Madam.
to the writ petitioner?
That is my
These are
point. Because
settled laws.
There are Supreme Court cases
Correct,
also.
it's a settled law.
Yes, settled law. When the game has started, rules cannot be changed.
Absolutely.
Yes.
The selection is still pending.
Has to be.
In case
according
you
to
had
the
cancelled the selection and you had
new selection,
new selection, then
advertisements were
it would
made,
have been a
then it
different
would have been
situation.
different.
But if this is pursuant to the same selection, which because of the pendency of the cases could not be completed,
yes,
just because in between some rules have been changed, how can you apply that retrospective qua petitioner?
Yes, my lord.
That is the point.
File my affidavit.
Yes, paragraph.
Paragraph number 6, my lord.
Paragraph number?
They
Six.
said only that.
Page 33.
Let's see.
Yes, my lord.
Because that cannot be
yes.
sustainable.
The deponent begs to state that as on date, there are 410 numbers of ASA and 20 numbers of ASA supervisor in position who are providing service in the health sector of South Salmara and Mankasar district. It is pertinent to mention here that ASA program, which is also includes the ASA supervisors, is a program of Ministry of Health and Family Welfare, Government of India. The guidelines and funds to implement the program are provided by the ministry. As per Government of India guideline issued by number so and so dated 28 February 2017, there should be only one facilitator, that is supervisor, against every 20 numbers of ASA to make efficient use of human resources. Therefore, NHM Assam is also bound to follow the guidelines. And the present numbers of ASA supervisor.
So you have, Mr. Chalian, now because of this ratio 1:20, your case has not been considered.
Yes.
You
Although we were selected in the list, we are in the waiting list now. Only 15 has been appointed.
No, you are still in the select list.
Right.
But because the zone has increased.
Yes.
Correct. The zone has increased.
Yes.
By the new guidelines.
Yes.
Earlier it was every 10, one post.
Yes.
Now every 20.
21 posts.
Huh?
Every 21 posts.
Every 21 posts.
Yes.
What is this 20 numbers of ASA?
ASA centers are there, Milord, in villages or
so
schools.
the zone has been increased.
Yes.
And because of which
Widen.
Because
That
of
is
that,
widen.
now you are not being able
Yes,
to.
we have been left out.
Huh?
We have been left out.
You are left out for appointment.
The selection process was done in 2018, my lord.
Yes, and these guidelines?
Guidelines is in my affidavit, my lord, page number 35.
This guideline seems to be of February 17.
February 17.
Yes, my lord.
And the, that selection which you had participated is of which year?
It is 2018.
18. But according to the old
Advertisement was
advertisement, there was
2008.
no fresh advertisement.
Oh, that advertisement was 2008.
Yes.
Yes.
That continued.
1 second. Advertisement is 2008. And selection?
2018.
Now
Selection
selection is
2018.
18. 18.
And this guideline
It's
is February
2017.
2017. And now you have done the selection again.
Yes,
But
ma'am.
in
For that,
for the same advertisement.
Yes.
No new advertisement.
No new advertisement.
You see, it is the advertisement.
That started in 8. That continued.
Paragraph 83.
Paragraph 30. It is, sir.
Here the facts are slightly different. There are more cases of the apex court direct on the point. I think you could have found another decision which fits the context of this case appropriately, because in your case, if I've understood it correctly, Mr. Chalia, here the advertisement was of 2008. You had participated and ultimately you were selected in 2018. Correct? You had
Yes.
selected.
Yes,
You
yes.
were selected in 2018. However, your appointment was not given in view of the pendency of two cases. Is it correct?
Yes, ma'am.
Now, after those cases are over, when they were reconsidering, in the meantime, because of the change of the guidelines, the scope, the zone has been increased.
Yes.
That is your case. Now, here, the para 30 that you're relying here, everything was completed.
But
Which
Yes,
part
Prakash.
of which part of para 30 you are emphasizing? It's a long
later
paragraph.
part, later part, because
The last part.
Supreme Court, however, induced a new regime requirement as to minimum marks in the interview by an
Where are you reading?
It is the towards middle of the paragraph 30.
Yes.
Full Court, however, introduced a new requirement as to the minimum marks in the interview by an interpretative process, which is not warranted and which is at variance with the interpretation adopted while implementing the current selection process and earlier selections. As the full court approved this resolution that demand, the administrative committee has also decided to retain the entire process of selection, casting a written examination. Therefore, we hold that the action of the full court.
Alright, I'm putting this matter on Thursday.
This is appropriate on the point,
Let's see. Ujjwal.
13 SCC 4 page 540 Test Prakash, Justice Selemester's judgment.
Yes, this is more clear.
Yes, is more clear. Exactly on the point.
Undoubtedly, held state or its instrumentalists cannot be permitted to tinker with the rules of the game, insofar as the prescription of eligibility criteria is concerned. But whether such a principle should be applied in context of the rules of the game stipulating procedure for selection, more particularly when change sought is to impose more rigorous scrutiny for selection, held requires an authoritative pronouncement of a larger bench. This matter was placed before the larger bench. We'll take it up on Thursday.
I will not be available, my lord, on
Thursday? And Friday? You're not there. All right, I'm taking it up for disposal right now. Heard, Mr. DP Chalia, Learned Senior Counsel, assisted by
M. Roy.
MSM.
Roy.
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 ROY. Learned counsel for the petitioner. Stop. Also heard MS.
A. Bora.
A. Bora, Learned Standing Counsel.
NHM.
NHM. Mr. CKS Bora, Standing Counsel, Health. Learned Government Counsel for the state. Health is also there. Anyone from Health? By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking direction not to give effect to the order dated 25/1/2022, whereby the NHM had directed the Deputy Commissioner cum Chairperson, District Health Society, South Salmara District, to conduct fresh engagement of ASHA supervisor in Gazari Kandi BPHC following the new revised norms within bracket 1 ASHA supervisor against 20 ASHAs and complete the engagement process. Stop. The facts of the case is that the Mission Director NHM Assam, by advertisement dated 22/10/2008, invited application for appointment of ASHA supervisor under the Rural Health Mission in the state of Assam. It is mentioned in the said advertisement that there will be one ASHA supervisor over 10 ASHA workers. Accordingly, selection was held. However, when the selection process was almost completing, some non-selected persons have challenged the selection process before this court on the ground that don't say on ground, by way of writ petition WPC number 4401 of 2009. Pallavi, sorry, তুমি সেই আগৰ writ petition যে কলো তাতে stop কৰি দিয়া. Pertinent that in WPC number 4401 of 2009, this court by order dated 7/4/2010 in respect of Gazari Kandi block PHC set aside the select list dated 25/2009 prepared at the district level as well as select list dated 6/10/2009 prepared by the state level committee in respect of Gazari Kandi block PHC, and the respondent authorities were directed to initiate the selection process afresh by interview, where is this order? Yes, it is not there. Where is it?
That's not there.
How will this court proceed if that order is not before this court? You have said you have craved leave to refer to this judgment at the time of hearing. Yes, Mr. Chalya.
No, my lord, because
No, you see, that order is important because this court doesn't know what has happened. Unless this order is placed before this court, how can this court proceed? It appears that the order dated Order dated 7/4/2010 passed in respect of WPC number 4401 of 2009, which has a direct bearing in this matter, is not available on record. Let the same be be furnished to this court on the next date of listing. List this matter after 2 weeks on a date to be fixed by the registry.
For every petition opposition, Lordship. Filing a petition opposition, Lordship.
You want to file opposition?
Yes, Lordship.
Objection?
Yes, Lordship.
You are for?
Respondent 7.
Who are you?
Mother-in-law, Lordship.
All right. You want to say something? As prayed for by Mr.
S.I. Talukdar.
I.
I.
Talukdar, Learned Counsel for respondent number 7, list this matter after 2 weeks to enable the respondent to file return in the matter.
No, can it be fixed a date, my lord? Because she is entertaining the, my lord, pension. I am not entertaining pension, my lord.
List on such and such date. Highly obliged, Your Lordship.
Item 26.
Area pay and allowances.
Yes, yes. And
No affidavits.
no affidavit, they are not appearing also. Last date, one council, and previous date, another council.
Why the affidavits of PNRD department is not forthcoming? In every matters. Yes.
My lord, in this matter, I have already sent for vetting, my lord. After the filing of the affidavit, lordship can dispose of this matter, my lord. Immediately after vacation.
Mr.
As doctor.
As Dr. Learned Counsel, Learned Standing Counsel, PNRD submits that the affidavit in opposition has been sent for vetting and assures the court that the same shall be filed
Immediately after the vacation.
immediately on the reopening of the courts after reopening of the courts. Stop. In view of the aforesaid assurance made by Mr. So-and-so, Learned Standing Counsel, PNRD, list this matter on such and such date. Give a date.
Give. 25th.
It is needless to be clarified that if the affidavit in opposition is not filed by the next date of listing, the writ petition shall be proceeded in accordance with law.
My lord,
28.
May it please your lordship. Lordship, this matter pertains to non-release of family pension and pensioner benefits. And the department has already filed their affidavit in opposition, wherein they have stated that the petitioner is eligible for pension. And but they the director has written a letter to the district veterinary officer on 5th July.
Annexure 1, Lordship,
Yes,
running
Ms.
page number
Kotoki,
40.
right?
Yes, Lordship.
Page?
Running page number 40, Lordship, of our affidavit, Annexure 1, Lordship.
Yes. Yes, it's already done.
But Lordship, the letter was sent 3 months prior to today.
It's taking
And,
time.
it's taking
Yes.
time.
Can it be disposed of, giving a time? You are for AG?
Yes.
This appears that it has already been sent. So, you guys,
Lordship, department shall process the case today.
Process the case, Lordship.
Lordship, if
I can, in view of this, I'll say that let the case of the petitioner be proceeded in accordance with law and the entire exercise be completed within 2 months.
Yes, Lordship.
Lordship, the provisional pension is also not paid till date.
Huh?
Provisional pension is also not paid. So, if I may, Lordship, may keep this matter pending and direct respond number 3 to speed up the process. And
Lordship, in
Lordship
that
may dispose it on
What
the
are
next
what are
matter.
your prayers?
Lordship, pension, pensionary benefits like DCRG, GIS,
So
CPF.
this is already taken care of.
GPF already.
Then what remains? Nothing remains. 28. Heard Mr.
A. Borwa.
A. Borwa, learned counsel for the petitioner, stopped. Also heard M.S.M. Kotoki. M.M. Kotoki, learned standing counsel.
Animal husbandry and veterinary.
AH&B Department, Mr. R.K. Talukdar, learned standing counsel, AG. Respondent number 5. Finance, anyone? Mr. H. Halia, learned standing counsel, Finance. By way of this writ petition, the petitioner is seeking release of family pension and pensionary benefits, DCRG, GPF, GIS, CFP, etc. of his wife, late Archana Borwa, who was working as a grade 4 employee in the Office of District Veterinary Officer, Animal Husbandry and Veterinary Department, Assam, Guwahati. Stop. Today, when the matter has been called, M.M. Kotoki, learned standing counsel, AH&B Department, draws the attention of this court to the affidavit in opposition filed on behalf of the respondent number 2 and 3 on 5/8/2024, wherein it is stated that the pension proposal within bracket CFP and sanction of gratuity within brackets DCRG are required to be uploaded in the Kritya Yatta portal of the Government of Assam by the concerned office, respondent number 3. Stop. And all it is further contended in the said affidavit that all relevant documents are needed to be sanctioned by the Accountant General, Assam, within bracket respondent number 5. And for sanction of General Provident Fund, within bracket GPF, for a supernumerary grade 4 employee like husband of the petitioner, should be directly submitted to the office of the respondent number 5 by the respondent number 3. Stop. It appears that respondent number 3 has accordingly taken necessary action regarding sanction of CPF and DCRG and the proposal of GIS and leave salary by letter dated 5/7/2024, which is enclosed as Annexure 1 to the affidavit, to the said affidavit in opposition. Stop.
It was issued by the director, Lordship, to veterinary officer. That's one number 2.
Not by 3.
Not by to him.
Director to respondent number 3.
So instead of director, instead of respondent number 3, it will be assistant director.
No, Lordship. District veterinary officer. Lordship.
Assistant director, district veterinary officer. A copy, relevant portion of the efforts.
Only district veterinary officer. From the assistant director to the.
This is the annexure at page 40, correct?
Lordship.
So the designation is given here.
Yes, Lordship, to the district veterinary officer.
It has been sent to the district veterinary officer.
Lordship.
Now, what will he is not an arrayed respondent?
No, he is respondent number 3, Lordship. He has already, he said that as per my information, he has already processed the.
All right,
all the-
all right, 1 second. তুমি কি বুলি ক'লা? কোনে পঠোৱা বুলি ক'লা? No, after that, after it further appears. Respondent not 3. Same. Assistant Director within bracket Livestock, Animal Husbandry and Veterinary Department has directed respondent number 3 to process with the CPF and DCRG and GIS and leave salary of the petitioner. Correct? Stop. Stop. Paragraph 11. This was para 11, na?
Lordship. 11.
Paragraph 11, 12, 13 of the aforesaid affidavit in opposition, along with letter dated 5/7/2024 is reproduced here under for ready reference. Okay? Look at that running page of Papa. Page 37 to page 40. Okay? Green, a yellow flag. MS M. Kotoki, Learned Standing Council, further submits that she has received instructions that the respondent number 3, after receiving the letter dated 5/7/2024, has already initiated the process for payment of for release of the CFP and DCRG and the proposal GIS and leave salary of the petitioner. Stop. In view of the aforesaid endorsement made by the Learned Council for the Learned Standing Council, AH&B Department, this court is of the opinion that this writ petition can be disposed of with a direction to the respondent authorities to complete the process of release of CFP and DCRG and the proposal GIS and leave salary of the petitioner in accordance with law, preferably within 2 months from the date of receipt of the certified copy of the order. Ordered accordingly, disposed of.
Obliged.
Department has to forward the proposal to the SC Lords.
See, I have not indicated all that. I have said complete the process. So you do it. Correct? Is it required? Because this clarification will unnecessarily perhaps process in accordance with law.
Obliged.
Disposed of.
May I please?
Yes, Mr. Doctor.
This is another covered case, my lord.
Covered case?
Yes, but covered by a judgment of the division bench, my lord. My lord, the SLP has also been dismissed, and thereafter the government also published a notification. But in spite of that, my lord,
These are all series. Is this a part of the series? No.
No.
This is wrong fixation of pension.
Yes, my lord. Yes. Page 90, my lord, Lordship will see the PPO, my lord.
Page
90.
19.
90.
90.
It's a PPO, my lord. It's a family pension now. The wife of my lord Thoronithor Bora is before Lordship. Now, page 90, Lordship will find the date of appointment is 5/2/61, and the date of retirement is 31/1/2001.
Date of
appointment, my lord, 5/2/61.
Yes.
Then, my lord, date of retirement is 31/1/2001.
Yes.
So, my lord, total service is next my lord, column, my lord, row, my lord, 39 years, 11 months, 26 days.
Yes.
Now, my lord, that has been not been considered, my lord. Rather, my lord,
14 years, 3 months, and 29 days has been deducted, my lord.
Non-qualifying service.
Non-qualifying service, my lord.
This is deducted.
This is deducted, my lord. This is contrary to my lord, division bench order, my lord. Lordship will find it.
This is what is challenged
Yes,
here.
my lord.
This deduction.
Yes.
Page?
Page 83, Lordship will find, my lord.
Ms. Bora?
Lordship, it's covered case.
Covered case.
Covered case.
Page?
83, my lord.
Yes.
Last, my lord, 5 lines, my lord.
Last
5 lines, my lord.
we are therefore.
Yes, my lord. Of the considered opinion, view that the benefit of the provincialization of the provisions of the Act, including that those of pension and other retirement dues, will be available to the provincialized employee in service on or after 1/10/91 on the basis of length of their service record.
So is it, if I dispose this in terms of this, that is all right?
My lord, there is a similar order, my lord. That's that page, my lord, 93, my lord. This is with regard to regular pension, my lord. I've got another order, my lord, where it is family pension matter.
93.
93, my lord. This is, of course, my lord, with regard to regular pension, but this is not a family pension granted to another person.
Which is your case?
Well, second one.
This one?
Yes, my lord. That is okay. Well, there are in fact, there are a number of petitioners have approached this honorable court, my lord, on the same, with the same, my lord, grievance, my lord. And there are numbers of orders, and this is one of them, my lord. Where, my lord, all these, my lord, initial service, my lord, from the initial date of service, my lord, date of appointment, my lord, the service period was not considered.
See, this is why I'm asking you. If it was covered by that 83, instead of going so much into the depth of the matter, can it be simply disposed of? That because both parties are saying it's covered by that.
Yes, ma'am.
And your case can be disposed of in line of that. So whatever direction is there will cover you. I think that is sufficient, or a detailed order like this is warranted.
Well, that's up to Lordship, my lord.
Because it makes no sense.
No sense, my lord. It's true, my lord. It's covered by that order, my lord. It is from the date of initial appointment. That's the crux, my lord.
Okay. Heard Mr. M. Dotto, learned counsel for the petitioner. Stop. Also heard MS and Bora. B-O-R-A-H. I'm sorry, I keep getting confused with all the names. Learned standing counsel. PNRD. Mr. CKS. Borua. Learned. GA Assam. Mr. H. Aliha, learned standing counsel, finance. Anybody else? Stop. By way of this writ petition, the petitioner is seeking grant of full pension and other retired benefits by considering the total length of service reckoned from the date of initial appointment of the petitioner in the service of the Panchayat.
Secretary.
In the service of the Panchayat?
Yes, ma'am.
Yes.
Stop. It is submitted at the bar that the issue involved in this writ petition has is covered. Where is that page?
But it's 83, my lord, but it starts at page 56. And
56, yes.
Relevant part is 80,
Yes.
83. It
Is
starts at
covered
56.
by the judgment of the division bench of this court rendered in the case of State of Assam and others versus Syed M.D. Fazlai Rabbi in WA 145 of 2009. Stop. Wherein the division bench of this court held that the benefit of the provisions of the Act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment. Stop. In view of the aforesaid endorsement made by the learned counsels for the parties, this court is of the considered view that this writ petition can be disposed of in line of the aforesaid decision of this court. Stop. Ordered accordingly. Needless to say that the provisions of the pension rules. Needless to be said that The total length of service shall be reckoned from the date of initial appointment of the petitioner in the service of the
Gram Panchayat Secretary.
Gao Panchayat Secretary in for grant of full pension and other retired benefits.
But it's a family pension.
Family pension. For grant of family pension.
And petitioner's husband, madam. Service of petitioner's husband.
Disposed of.
Lordship also may refer to the date, madam, from the initial appointment 5 to 61. That will make things a little clear.
I 5
to 1961.
to 1961. 61.
And the areas will also be released within the time frame, madam.
Date of petitioner's husband, right? Petitioner's husband retirement.
Lordship, kindly fix the time frame, madam, for payment of the areas.
In the other matters, time frame has been given.
Yes, madam.
3 months.
In some 2, in some 3, madam.
Needless to be clarified also that the entire exercise shall be undertaken and completed within a period of 2 months from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number.
Respondent number, my lord, 2. 4 and 5, madam.
4 and 5. And in the event and in the event such exercise is not completed and failing to complete such exercise within the stipulated period, the same will carry an interest of 6% per annum. Writ petition stands allowed to the extent indicated above.
May I please, Your Lordship, within 3 months.
It is given in the earlier cases.
Oblige.
Oblige.
In all these cases, my lord, pleadings are completed.
Yes, Mr. Mahanta.
My lord, another, these are the candidates, my lord. They appear in the interview as per direction of this honorable court. So the court allowed them to sit in the examination, and accordingly, my lord, they are but subject to keep their result in seal cover. Seal cover. So, my lord, definitely, my lord, we all the results, my lord, result of this petitioner we kept in seal cover. If your lordship allow me to place it before this honorable court, if they pass, my lord, then there is matter can be, my lord, heard. Otherwise, it will be, my lord, academic interest only. But some of them, my lord,
what I understand, my lord, if my learned friend places it on food, and my lord, the status of my client I get to know. In that case, my
Why
lord,
can this status not be put by way of an affidavit?
My lord.
Can the status not be disclosed by way of an affidavit?
No, my lord, there is a order from this honorable court to keep in seal cover.
The
So
result.
their yes, their result. Those who are, my lord, appear as per the.
No, I've understood, but now, as the further course of action would indicate, upon perusal of the results, correct?
My lord,
you're saying that the
no,
further
my lord,
course.
my lord, my submission before your lordship. If your lordship allow me to place the result before this honorable court, and your lordship kindly open it, my lord. After open it, my lord, if my lord, those who are
Right.
passed.
Where are the records?
No record, my lord. If your lordship ordered, then only I can, my lord.
Oh, it's not available with
Not
you.
available.
they will place it on
They will-
fourth.
on fourth, my lord. If your lordship, my lord, asks, I can.
All right. Where
In
is
that
that
case-
order?
Order,
In
my
that
lord.
case, what will happen?
Order dated, my lord, in all cases, my lord. Similar order was
Just
passed.
show me one of the order.
Yes, my lord. Order dated 27/6/22. Item number 31. Your lordship kindly take up only item number 31.
31 to do.
Item number 31. Order dated 27/6/2024.
27/6.
Straightway goes to para 9, my lord. Of the order. Para 9.
Mr. T. Mohanta, learned senior counsel, assisted by
P. Sharma, Lord.
MSP Sharma, submits that pursuant to the completion of the selection, the results of the petitioner are kept in sealed cover in terms of the order passed earlier by this court on 27/6/2024.
In respect of other, my lord, maybe my lord, order there may be difference in other cases, my lord.
Others,
but the order is same, my lord.
It's all right. Stop. I'm passing this order in 31.
My lord, I'll keep it, yes.
And the rest are tagged.
My lord.
Stop. Let the results be placed before this court and seal cover on the next date of listing. Correct. That's the order you want?
Yes, yes.
List again on?
Fourth, my lord, I can, yes.
On such and such date.
I could have on
You are-
third, my lord, tomorrow is holiday.
Sorry?
Tomorrow is a holiday, otherwise I can, my lord, place it on
No,
third.
it's all right.
On fourth, my lord. Keep your.
No place.
Lord,
Yes.
there was an order from this honorable court directing them to file an affidavit.
I don't see any affidavit
Yes.
in my index.
My lord,
No affidavit filed.
what happened, my lord, let me explain it. My lord, the United Bank of India was amalgamated with the Punjab National Bank. And the record, usually it used to be in the head office of United Bank of India at Calcutta. My lord, in the meantime, my lord, their Delhi office is the main office,
See,
my lord,
Mr. Datta,
where they
you
retain.
may have valid reasons and explanations,
Well,
but when matters are, when orders are passed requiring you to file something, failing which the consequence is given, then maybe a small application
my lord,
for
true, my lord.
extension would have been more
Yeah, exactly. I accept.
appreciated.
My lord, I understand that. My lord, what happened?
All
Because
right,
of that,
we'll give them the
My lord,
chance, Mr. Chakraborty.
my lord, this amalgamation of UBA with PNB took place in 2020.
But these affidavit would be required, isn't it, for an effective disposal?
My lord, in absence of the affidavit, if your lordship grants me 5 minutes time, what was to be done and what they have actually done?
All
Now, my
right.
lord, lordship will grant me
Where is
5.
the prayer? Where is the prayer?
Yes. Prayer is to set aside the order of punishment. Now, my lord, on the day of his retirement, one charge sheet was served.
You are not in service right now.
Yes, retired in 1999, my lord.
Anyway,
My
yes,
lord, that was a
how
direct.
much time?
my lord, let it come after vacation, my lord. Your matter.
Mr. Datta, this court only because you are asking is giving, and considering the fact that the petitioner is already, but then this cannot go on in this fashion.
My lord,
It's
I
a
understand.
matter of 2018.
Yes, yes. I'm conscious of that
He's
position.
out of service from 18.
And my lord, only one thing I can
And if
indicate.
the order is bad,
Yes, yes.
then it doesn't look good because he's out of service from 18. We are in 24
No,
now.
my lord, he has gone on retirement. This
I don't-
proceeding went on after retirement.
I don't want to take any
All right.
defense.
Anyway, as prayed for by, as assured by Mr. S. Datta, Learned Senior Counsel, assisted by MS K. Bora,
S. Musahari.
S. Mushahari, Learned Counsel for the respondents, despite last chance being given to file the return by today, by comma, another chance, another opportunity is given. Stop. List this matter on a date.
Yes, just
22nd
after
October.
22nd? On
Instead of
22nd,
22nd,
so and so. It is needless to clarify that the issue involved being
23rd.
being pending since 2018, the respondent shall file their return by the next day, positively file their return on the next date of listing as assured by the Learned Senior Counsel.
My lord, your lordship can fix it on 23rd.
23rd.
Obliged.
Lordship may kindly peruse the order dated 18/9/2000.
Yes, affidavit. Mr. Goswami, 22 matter on September 24. Time was taken. In fact, assurance was given. You don't have the file? You don't have the file?
It is 49.
Supplementary. 48. WPC 6855. It's not filed, the affidavit not filed. Though MS M. Bhattacharjee, learned additional senior government advocate, had assured that the requisite return shall be filed within 10 days. The same appears to have not been filed till today. However, Mr. J.K. Goswami, learned additional senior government advocate, appearing for the state respondent, yes.
Yes, Lordship, I am on behalf of I am on behalf of one.
No, but what about this? You are appearing for the state government, no? 3 and 4?
Yes, Lordship.
Yes. Are you aware? If you don't have information, I will say you are not having the information.
No, 3 regarding the affidavit, Lordship. Affidavit can you fix the matter after vacation?
Does not have the information as why the said affidavit has not been filed as assured. Stop. Be that as it may,
Date may be fixed.
as a last chance, the matter is posted on such and such date, by which date, if the return is not filed, the petition shall be proceeded in accordance with law.
23.
8 November.
8 November.
No affidavits again. Yes, Mr. Dubey?
My lord.
This is that matter.
Yes, tomorrow,
Yes.
yesterday
Yes,
matter.
yes, yes.
Already your lordship.
With me, my lord. I have the records with me. If the lordship kindly peruse the flag mark, my lord.
Rupak. This is that according to the petitioner that RED concerned the delegation.
Yes. There one violation, then 4.1 violation.
4.1 and 4.3.
3. And exemption under clause 10. And my representation was also disposed after 20 days.
What are you trying to show from this submission of transfer options?
Yes, my lord, kindly see that flag mark page, my lord.
Yes.
At the third column, my lord, that there is a table, the details of station-wise actual strength, sanction strength, and vacancy position.
Yes.
My lord, kindly see at serial number 2.
Yes.
It's Bada Pani.
Yes.
My lord will see as regard its category of senior superintendent and superintendent. The sanction strength is 1. Actual strength 0. My lord, there is no 1. And vacant is 1.
What is AS?
Actual strength.
That is 0.
0. My lord, because there is a vacancy. Now at serial number 10, your lordship would see.
Silchar.
Yes.
AS2.
Yes. Actually, strength is 1. There are 2 persons. 1 is additional. Now there are 2 persons therein. One is Mrs. Suklapadhyay, regarding whom averment has been made at para 10, Lord. Lord, she has undergone hip transplant. Yeah. So there is also a report. Lord, we have annexed. Sorry, it's there in the record certificate from the government on 17/7/2024.
Yes.
She had undergone hip replacement, Lord. And that's why, Lord, she has not been transferred, Lord. So far as other persons are concerned, Lord, they are under deputation with Adani in Guwahati. And Lord, therefore this, and Lordship would see the pre-page of that flag mark, Lord. There is a handwritten note.
Yeah, where?
NP6, Lord. NP6.
This flag?
Yes. Just Lord, one page earlier than that. One page earlier than that. Yes, that page one. At the bottom, your lordship would see transfer option forms of inter-region. It's been written in hand.
Transfer option form.
Yes. Well, there is a committee, Lord.
This matter had come up for consideration of the interior.
Yes.
Motion,
My
right?
Lord.
No, but his contention is that the concerned officer has not issued the
No,
transfer
that is
order.
I'm showing your lordship.
There is one, your lordship.
Oh, yes, yes, it is there. In
Lord,
view of
it
above, the
transfer
file
committee
is-
has worked out entire thing, Lord, and it has been placed before the regional executive director, Lord, who has approved this, and thereafter that order has been passed.
It is there. It is there. You
And
will have
Lord,
to file an affidavit.
Yes, we will file, Lord. Just we are showing your lordships, Lord.
So let them file affidavit, your
Let them
lordship.
file affidavit.
Yes. And some interim protection may be given here.
It's a transfer matter, Mr. Counsel. Prima facie malafide has to be established. Records are placed before this court.
Your lordship, I have already, as per 4.3, it is a prima facie established, your lordship.
Yes, I have noted your argument and
Yes.
I'm going to deal
Then
with your
4.1 seniority, if he is
This is
citing one
item number
example,
50.
there are others
Your
also.
name?
R. Majumdar, your lordship.
Heard Mr. R. Majumdar, Learned Counsel for the petitioner. Stop. Also heard MS R. Dubey, Learned.
Let MR, Lord. Lord, it has come. R. Dubey for airport authority, Lord.
Sorry.
228.
MR, I'm sorry. You were saying something.
228. Respondent 228.
Respondent 228.
One is not required, Lord. Otherwise, it is not.
One is
Mr.
a formal
Dubey?
parties union. One is a union.
Okay. Stop. By way of this writ petition, the petitioner is assailing the impugned transfer order dated 2/8/2024. So far, it relates to the petitioner, as well as the impugned relieving order dated 4/9/2024. Stop. By intra-region transfer order dated 2/8/24 issued by the respondent number 5 on behalf of respondent number 4, the petitioner has been transferred from Silchar Airport, Kumbrigram to Borapani Airport in the capacity of Senior Superintendent within bracket HR Group -C. This is the transfer order that is under challenge.
Yes.
In view of the petitioner's daughter's mid-academic session and serious illness of his wife and mother,
87 years.
he submitted representation before the authorities on 7/8/2024 for cancellation stroke deferment of his said transfer order. However, the authorities, by order dated 4/9/2024, issued the impugned transfer of Group D staff under the administrative control of RHQ, by which the petitioner stood relieved of his duties from Silchar Airport on the afternoon of 6/9/2024. Stop. Accordingly, the present writ petition has been filed, assailing the aforesaid orders. Stop. Issue notice, returnable 4 weeks. You're accepting for all.
228.
So and so accepts notice for in respect of respondent number
228.
228 and 1. Mr.
CG
S.S. Roy.
CGS.
Mr. S.S. Roy for 1. Extra copies. 3 days. Within a period of 3 days from today. Stop. In support of the interim prayer, Mr. So-and-so learned counsel for the petitioner submits that the impugned transfer order is in violation of clause 4.1 and 4.3 of the transfer policy. Stop. He submits that as per clause 4.3, transfer of Group C staff under the administrative control of RHQ is required to be done by RED concerned. Stop. He further submits that in the present case, the impugned transfer order, having not been done by the RED concerned, suffers from jurisdictional error and accordingly is bad in law. Stop. Stop. In order to test the aforesaid submission, this court had directed accommodated Mr. So-and-so learned counsel appearing for respondent number 228 to place instructions before this court. Stop. Today, when the matter is called, Mr. So-and-so place the record. Is there a name of this file, Mr. Dubey?
I think it's part of
The concerned record as regards HRM annual transfer 2024, from where it appears that necessary approval of the concerned authority, i.e. RED-NER, has been obtained before passing the impugned transfer order. Be that in view of the aforesaid perusal of the aforesaid record, appears that the petitioner has failed to make out any case for warranting interim relief as sought for. Accordingly, the interim prayer is rejected. Let the returns be filed by the next date of listing, list after 4 weeks on a date to be fixed by the registry. And records is returned.
Your Lordship, the steps has already been taken in your Lordship as per your earlier order.
Steps,
already
okay.
steps
Yes, yes,
taken.
will they-
18-9 already step taken.
So
Your Lordship,
then, but notice was not given.
But notice was issued, my lord.
Notice was issued
yes.
only for the interim to do.
Notice was issued for 1 week, my lord, and it was for consideration of
Hey, can you just
Other- Your Lordship, may I interrupt?
Yes,
Your Lordship?
next matter, please.
Only one thing, Your Lordship. Only one thing, Your Lordship. Approve, it cannot be delegated, Your Lordship, as per the policy.
All right, let them file their affidavit. I have not disposed of your case, Mr.
Yes.
Counsel.
Some protection, interim protection may be given,
Yes,
Your Lordship.
next.
My mother is also 87 years, Your Lordship. And as per the seniority, they have discriminated, they have considered her case, but not mine, Your Lordship.
Just one second.
All right, Your
It is a settled law that in order to obtain interim relief in matters of transfer, mala fide prima facie has to be established. Reference is made to the so-and-so case of the apex court. I'm writing that. Yes. List of admissions. Orders. Yes. So which one is to be taken today? I was hearing 5. I see there is a change of position.
No, item number 2 is mine.
Yes, but 5, I've been hearing 5, right?
Yes, on the last.
5 is over.
They have replied me.
Mr. Gogoi, 5 is over. So item 2 is yours.
Last occasion, Mr. Mojumdar started at number 2 after finishing it. RS replied, after search replied,
But isn't 2 related? Outcome of 5 will
Definitely.
Perhaps
It will affect me. And
affect item
But
2
my
and
lord,
3.
there is one gross suppression of material fact in my learned friend's petition. My lord, assuming what he's saying is correct, on 19/9 only an in-charge director has been appointed. On 19/9/2024, an in-charge director has been appointed. So his order was passed on
5/9.
5/9. So my lord, in the writ petition, which runs into almost 60 odd paragraphs, he has narrated the entire history, but he has not narrated the fact that on 19/9/24, my lord, only an in-charge director was appointed. So prior to that, respondent number 9 was holding the office.
You are R9.
I'm R9. So he must explain, my lord, why he has suppressed that fact.
Here
Because otherwise it contains everything.
you have filed your returns here.
In fact, Lordships wanted that we should file a short synopsis, which I have done, my lord. It only runs into 3 pages, my lord.
Is it,
Not 3,
has it
3
been
4
furnished to
pages.
the court?
No, I have given the
Okay.
related annexes, but only 4 pages.
All right. In fact, on the last occasion, Mr. Majumdar had also handed over a
Yes.
spiral minded copy. Have you received it?
No, what happened is, my lord, after that day, I got hold of 2 more writ petitions, and there were documents which had to be annexed. I have got 6 copies. I can.
So are you replacing this?
My lord, that would be replaced. I have got a little bit of it, my lord. Only few documents would be added. Otherwise, serial number almost remains the same.
Looks like I'll have homework in the vacation. Yeah, are you replacing it or?
Yes. So
this
is petition file is almost. Petition jimanখিনি file is
the first one is
copy পাইছো তাৰ মানে annexes বিলাক in a serialized manner.
Mr. Chaudhary, this compilation of yours is in both the WPC 5054 as well as 37.
Yes. Just 4 pages, my lord, because Lordship wanted to have the chronological.
Those are the 2 writ petition which you have filed.
My lord,
5054 and
the first
3769.
is 3769
and second is 5054.
5054. And my lord, if your lordship kindly comes to the 4th last page of that compilation.
And Mr.
At least
Majumdar, your compilation is also relatable to the issue in hand.
All the
You're covering
all
the
the
entire issue.
annexures of all the writ petitions I have tried to bring on this, all the important, the relevant ones.
All right. Yes. So since Mr. Chaudhary, you have already finished in item 5 and the respondents have also finished.
We have all completed.
5 I think is completed.
Yes.
Let us now come to the. Huh?
On third, I will provide a short note.
On 3rd.
I will provide a short note. Today I am not meeting.
Okay. Yes, Mr. Majumdar, let's hear you.
At first,
The compilation. If I so issue now appears. Oh, what happened?
No, he wanted a copy.
You
of the
have
new
a copy or
compilation.
not?
New compilation I have given everybody.
Do you have a copy or
Yes,
not?
my lord, I have got 2 extras.
So issue appears twofold now. One is about that
Director.
age of director, and second is age of superannuation parity.
Yes.
Isn't it? It is
Yes.
ultimately coming to parity of the age of the superannuation.
Yes.
Okay.
So the issue would be if he's a professor and director, then whether he's a professor in the.
As regards that professor thing, I think Mr. Gogoi's argument was that these are given by the by the petitioner himself in being a member of that board, and therefore they are not. This is what were your arguments?
Recruitment rules
All right.
He should be
All right.
he should be a professor.
Yes, Mr.
My lord,
Majumdar.
on the last occasion,
Only one thing, my lord. If your lordship would kindly have the fourth page of that compilation which I have given today.
Yes.
If your lordship would kindly come to that note.
Yes.
If your lordship would kindly find one sentence that the government of India, somewhere in the middle, only finalize the pension benefits after 18 years of takeover.
Can you give me the date?
My lord.
Is there because there are date in your note.
that is my lord, I think page number 142. It is there.
142.
I think so, my lord. Of the
no 142 corresponding is Rule 919 of Fundamental.
No, one second, my lord.
You are referring from the chart, right?
Yes,
Mr.
yes,
Chaudhary?
yes. No, I'll give that. My lord. Kindly give me 1 minute time. Oh, 103 na reply to na. Yes, yes. Please come to page 103, my lord.
Date is 10/10/17.
Yes. 1 second. 103. Yes.
Yes.
I am directed to refer to your letter number so on the subject mentioned above, and to convey approval for creation of pension cell at Tezpur for disbursing the pension benefit and other post-retirement benefit or to inherited employees as per the Assam Service Pension Rule. So all that was clarified was only pension part, Miller. Other terms and conditions were never settled. That's what we have highlighted, Miller. If your lordship would kindly permit me to read that last page. Government of India only finalized the pension benefit after 18 years of takeover, that is in 2017, as per Assam Services Pension Rule, since they are originally
Mr.
Assam
Chaudhary, you
government.
are reading at page 103.
No, yes, 103 was the document by which, my lord, only pension part was answered.
Yes, and then
Other terms and conditions.
I have understood, but you are reading something now from where?
With that last page of that compilation. That note. Fourth page, Miller.
Yes.
Yes.
It starts from note.
Yes.
Dr. Deori was working.
Yes. Then Milord will kindly skip the 6th line. The government of India only
finalized.
Yes.
Okay, got it.
The pension benefit after 18 years of takeover, that is in 2017, as per Assam Service Pension Rule, since they are originally Assam government employees. Other conditions of service like benefit, medical benefit, promotional avenues are also not finalized and ultimately rejected for him in 2020, denying him for CHS Kadar. Yes. GPF accounts are still under Government of Assam and have not been transferred to the Government of India to date. Hence, even though Government of India has taken over the institute, they have not finalized, settled the terms and conditions of these employees and have kept their service condition equivalent to Assam government. Therefore, my lord, to say we cannot rely upon that Supreme Court case that you cannot become professor and, my lord, director at the same time. You also can't say that I'll retire at 65. You also can't say that my tenure is 5 years because nothing has finalized. It's a peculiar case, my lord.
So therefore, when
Yes.
the service condition for the age of superannuation is
Yes.
increased for Assam government
Yes.
employees, why it should not be given to
Yes. If not, then as a central government employee under that rule clause 7.2. That is all.
So, at 2, another part heard appears to be is fixed. So we'll wait. And the difficulty is that I'm also in the midst of another part heard hearing matter, which has been continuing since last 2 days.
Today it was fixed for Mr. Borwa to produce those affidavits. I was supposed to produce those records of the pleadings that has in the previous case, but unfortunately we couldn't trace
Then
out
I'll
the file.
post it after vacation.
At the same time, Lordship may call for the disposal of matter may be taken so that
You have the numbers?
Yes, we have. Number is there in the judgment. I'm just
Just
giving.
give.
Yes, I'm giving.
Is it ready with you? Otherwise, I will.
Yes, yes, yes.
Huh?
It's ready.
Ready?
Yes.
In item number. This is item 40, right? In item 40, you say.
If your lordship permits, we can submit a list of our submissions.
Yes, yes, that would be
WPC 91.
appreciable. One sec. Mr. Mr. S. Borwa Leonard, SCPCB, submits that the compilation of the affidavits,
Pleadings.
compilation of the pleadings as desired by this court as per last order dated 24/9/2024 could not be done, and accordingly seeks accommodation in the matter. Prayer is allowed. List this matter. Give a date. It's a part-heard matter. On such and such date.
Also, at the same time,
Let the records of WPC
914 of 2009. 912.
I have it here. 912 of 2011 be called for and placed. No, the record be tagged, no? Tagged along with the present writ petition.
24th, my lord, if it is not inconvenient for my lord.
Okay.
Out of abundant caution, 912 of 2011 was also tagged with 6329 of 2013, pertaining to same subject matter. That dispute was between petition number 2.
That also needs to be called.
Just abundant caution.
And WPC
6329.
6329
of 2013.
Of 2013.
Just so your lordship has all the records.
Both these writ petitions are disposed of.
Disposed of by the same order.
Legible disposed of.
On 24th month. I'm grateful.
Why?
Material instruction.
Developer support DD.
Lordship with,
all right, it will be recorded.
Lordship, with regard to item number 47, hearing Lordship. I've taken the consent, Lordship. Let it be after the petitions, Lordship.
47?
Yes, Your Lordship.
All right. As per
47.
47, there is no hearing. Please verify the item number. It is 46.
45.
45 or 46?
45, my lord, is this item.
In item 45, as sought for by Mr. S.S. Roy, Learned Assistant
CGC.
Learned CGC, which is not opposed by the other by Mr. R. Majumdar, Learned Counsel for the petitioner, lists this matter after 2 weeks on a date to be fixed by the registrar.
On the same note, my lord, item 41 and 42.
41 and 40?
42, my lord.
42. Here, as prayed for by Mr. R. Majumdar, which is not opposed to it. Councillor Namdi Budalaga. Yes. You are there in 46 also.
46, my lord, a very young boy is out of service. If I may pray for a date, any other date.
Okay. In item 46, as prayed for so and so, immediately after vacation, another date did you?
One item,
item 36 may kindly come up.
No, I am taking orders. Orders, now please call the orders. After finishing the orders, I will take up Mr. Chaudhary and Mr. Majumdar's part-heard hearing matter.
This case, we have filed the affidavit. Though contempt petition, my lord.
Where is the petitioner?
Petitioner, my lord.
No contempt. Which is
Actually,
the order?
Survive, my lord. Honorable Court's direction was that to give my lord, notice to the petitioners. We have given the notice. They have appeared before the authority, my lord. Therefore, order has been passed.
Just point out two things. First, the order of this court. Where is that?
Order is the court page number, my lord.
26?
26. 22 to 26.
Huh?
22 to 26.
No, operating part.
26.
No, it will be, I think
Para number 13.
It starts from 8. The respondents are according directed to rectify the mistake. A reason order be passed.
Reason order we have passed. They have challenged that order in the second petition. In that petition, already notice has been issued. So, we have called them. They have appeared before the authority. We have passed and vision order, my lord. That order again challenged in the second petition.
So you were directed to give them a notice, hear
Notice.
them, and pass an appropriate order.
Yes, yes.
Now, there in your affidavit,
Affidavit, my lord, yes. Page 39 is the notice, my lord.
no, you please give me the averments, paragraph number.
Paragraph, my lord. Paragraph, my lord. Five, start from 5, my lord. So he is start from 5, but our affidavit regarding notice part is para 6, page para 6 of the affidavit. The answering respondent authority begs to state that the respondent authority acted as per Honorable Court's direction and served notice to the petitioner via letter dated 14/12/22. Subsequently, the petitioner via his letter dated.
Where is the speaking order?
Subsequent petitioner's reply, 3, annexer number 3, page 43. He has submitted the reply, then we have passed the order.
None appears for the petitioner when called. Heard Mr.
K.K.
Parashar, learned counsel for the respondents. Stop. By filing this contempt petition, comma, the petitioner has brought the attention of this court to the alleged willful violation and disobedience to the order dated 16/11/22 passed by this honorable court in WPC number 52 of 2019. Stop. Pursuant to no issuance of notice in the contempt proceeding, comma, the respondents have entered appearance and have filed affidavit on 21/12/2023. Stop. Mr. K.K. Parashar, learned counsel for the respondent, submits that the order of the court has been duly complied by hearing the petitioner and passing a speaking order thereof. Stop. I have heard, perused, halke likhe dibaite. By order dated 16/11/2023, this court in WPC 52 of 2019 directed passing of a reasoned order after issuing notice to the petitioner in connection to his claim for relaxation.
Relaxation in height.
As regards his height, in order to allow him to participate in the written examination. Correct, Mr. Parashar?
In the selection process of the
in connection with the selection process
of constable Assam in
of
Assam
constable
in Assam Rifles.
In Assam Rifles. Stop. Paragraph 6 of the affidavit in opposition filed by respondent number 1 on 21/12/2023 indicates that the order of this court has been indicates that after issuing notice to the petitioner by by letter dated 14/12/2022, and upon considering his reply letter dated 10/3/2023, the authorities passed the, where is that main order? Passed a speaking order dated 29/3/2023, whereby the prayer for relaxation was rejected. Stop. Paragraph 6 is reproduced here under for ready reference. Page 35, A to A. In view of the above, apparent that the order of this court has been complied, hence nothing survives for adjudication in the contempt petition. Accordingly, contempt petition stands closed. Disposed of. 36. Yes. 36. Yes.
Notice was issued, my lord, after receiving notice, my lord, they have written a letter to the registry. That is, my lord.
Written a letter to the registry.
My lord.
For what?
My lord, you may kindly see order dated, my lord, 1810.
Yes.
My lord, Mr. Bora was directed to communicate the respondents to.
Yes, this I have noticed. In many cases, they do that. They straight away send their reply to the registry. That is not acceptable. Yes, have they? But Ms. D. Bora, I think State Council was directed to convey and take necessary actions. Where is she, D. Bora? I think the name is not shown. Perhaps that is why Shri D. Bora, the State Council must have missed the matter. List this matter after 2 weeks on a date to be fixed by the registry by reflecting the name of Shri D. Bora, Learned State Council. Yes, Mr. Majumdar.
A prayer for restoration of the petition, my lord, which was dismissed for default.
Where is the order?
My lord, we'll find the order at page 9.
Yes, what is the ground?
My lord, the ground is that on the first occasion, the item was missed because the concerned council was
yes
gone to the answers nature's call, but
okay.
Second occasion, my lord, there was an oversight. We missed it on the list in the morning part. By the time we came to the court,
all right, subject to 5,000.
She could consider a little
unnegotiable.
A little.
Heard Mr. R. Majumdar, Learned Counsel for the petitioner. Stop. Also heard.
I'm P. Hazarika on behalf of
Mr. P. Hazarika.
Yes.
Learned Counsel for respondent.
On behalf of SR Rabha, BTC.
Learned Counsel on behalf. This proxy things become very difficult. Mr. So-and-so on behalf of Mr. R. Rabha. SR Rabha. Yes. Learned Standing Counsel BTC. Mr. Hendik G. Assam.
No,
Standing Counsel Revenue. And Mr. J.K. Goswami. Yes, your name is there. Huh? J.K. Goswami, Learned Additional Senior Government Advocate for the State of Assam. By way of this application, the applicant is seeking restoration of WPC number 2977 of 2019, which was dismissed on the ground of non-prosecution by this court's order dated 13/9/2023. Stop. Heard the parties. Peruse so and so. Paragraph. Yes, grounds are stated where? Paragraph
3 and 4. Paragraph
3 and 4 of the said interlocutory application is reproduced here under for ready reference. Apparent that the grounds stated are sufficient for restoration of the writ petition, which was dismissed for non-prosecution. Stop. Accordingly, WPC number 2977 of 2019 stands restored to its original subject to payment of rupees 5,000 to the employers. Ki asil naam to? Employers, principal seat, employees association. Disposed of.
Obliged.
Yes, 38. None appears for the petitioner when called. List after 4 weeks on a date to be fixed by the registry. 34 days delay. Notice issued. Huh?
34 days delay.
Notice not issued.
Notice not issued.
Who is there? State, Mr. Goswami, are you accepting notice for all? Because it is only 34 days delay. If you don't have objection, I'll condone.
Yes.
You condone the delay. Grounds?
Ground for that I have listed in para 4. On 22/8/2004, my lord.
All right.
For listing.
Item 39. Huh? Heard Mr. P. Talukdar, Learned Counsel for the petitioner. Stop. Also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate for the state respondent. Stop. By way of this application under Section 5 of the Limitation Act 1963, the applicant is seeking condonation of delay of 34 days for preferring the accompanying application under Order 9 Rule 4 of CPC 1908 for restoration of writ petition I WPC number 435 of 2020, which was dismissed for non-prosecution on 25/6/2024. Stop. Heard the parties peruse the application. Full format likhe diba. Paragraph
4.
Paragraph 4, 5, paragraph 3, 4, and 5 of the aforesaid application is reproduced hereunder for ready reference. Apparent reading of the aforesaid grounds that the grounds explained are bona fide and sufficient, and accordingly the delay of 34 days is condoned. Stop. Application allowed. The accompanying IA is registered.
My lord.
Condoned. Disposed of.
Right.
The list otherwise is complete. No?
My lord, in this case, before my learned friend starts, better we file a counter in this case, my lord. Counter, because lordship will not stay this order, because the stay means claimant allowing the writ petition. Therefore, we will file a short counter, my lord. Otherwise, in any case, my lord, everything will depend on the outcome of that case. If your lordship
No,
holds,
but since that case is part heard and probably now Mr. Gogoi said he will file something tomorrow, right? On 3rd.
he says he will file a
Yes,
written.
so I was thinking of posting it on 3rd, and if everything is completed, then I was thinking of reserving it.
Yes.
Because since the hearing is completed.
Otherwise,
correct.
Yes.
Now, if you since this matter is tagged, I think 2 things we can do.
Yes.
I can release it, untag it, and this matter can always, whatever happens there will always be there. And in the meantime, they will get a chance to file their
What happens is,
return.
when this matter is decided, if at that point of time the things that I have to say are not taken up in consideration.
But your case is a different case, Mr. Majumdar.
No, my lord, as I understand, his case is that since in terms of the interim order, I couldn't have exercised the power of director.
See, Mr. Majumdar, for deciding the issue involved in Mr. Chaudhary's matter, your presence is not required otherwise. You are not challenging that.
No, his continuation is under challenge in another repetition in a co-warranty matter.
No,
that is
but
there.
are you challenging his continuation?
In this matter, that he could not
Huh?
have been from
You
that
are
particular-
challenging
Yes,
that.
yes, yes. Yes, that is a matter of
So,
challenge.
so
in
it
this
has some connection.
case. It has, my lord.
No, my lord,
It's
what
not
I'm
any-
saying
what-
is, in the matter which I have filed, I said that I should be allowed to continue up to a particular point of time.
True, Mr. Chaudhary, but Mr. Majumdar is also contesting that part, right? According to him, the petitioner could not have.
No.
continued.
What I'm saying is, my lord, matter is very simple. The going by the synopsis, my lord, the case made out is that on 31/7/24, I was sought to be released. Then I filed a writ petition, and in the writ petition there is an interim order.
How much time do you need to file your counter?
At least, my lord, a week's time.
No, because you see, these matters have been taken up for hearing together. It would.
Only yesterday, my copy was, no? Yesterday only copy was.
Why notice was not
No,
issued in your
no,
matter?
on him, notice was not issued because on the first day, they would be tagged together. Then it was taken up tagged together. We were all on a consensus that it has to be. I have to place my case to some
No,
extent.
I am not
to
saying
bring
that
it
it should
No,
not be
I
tagged.
understand. I'm just trying to find out a way to accommodate you both.
When
Yes.
the matter has come up till today, other matters have been kept apart. Listening, hearing me. As
All
of
right,
today,
then I
let
can
them-
do one thing.
lots
I
of
can post this matters on the reopening day,
Yes.
and by then you file whatever
Definitely, of
return
course,
you
you
want
can
to
file.
file.
Yes, yes.
But there's only one thing that I would like to show. Madam. What I was trying to impress on the very first day. A length of time given, situations change. Even on the website, the constitution has changed. Pages have been added. We've
See,
seen
in that
So
situation,
therefore-
Mr. Majumdar, this court will go
I
on
know.
with the.
No, that is what
this
that
court
is what
will
I was saying.
complete as far as the other case is concerned.
I
But
know.
as far as your case is
No, no.
concerned, Mr. Chaudhary has a right to file.
Yes, he has. Once his
affidavit.
notice is issued.
How can
No, once notice
this
is
court
issued,
decide that petition without giving them that right? Correct?
once my petition will not be decided is what was there from Lordship on the first day. It
Very
will not
well,
be
then
decided.
we will.
If I just have the opportunity of placing some facts which would have a bearing on Lordship's decision on his case also. Because I have taken the pain, Lordship would perhaps appreciate, I have taken pains to go through it
that
for
document
3-4 days.
that compilation is from the available records,
Only.
right? So there is no impediment for this court to go through those
And-
papers. Those are not some.
No.
Are there any?
When he is not
Is
a
it not?
party in my.
No, Mr. Chaudhary, not that. He has compiled the documents of all the pleadings. So the documents are all pleaded.
Yes.
Part of pleading. So is there any bar for this court to look into those
That
documents?
is what I was trying only to
That's what
say.
this court can
I would-
anyway.
I was just trying to say that if Lordship goes through these documents,
All right, your
perhaps-
documents, this court has kept it. This court has kept it because you are not bringing in any new documents or.
documents which were filed by the
Correct, I understand.
earlier also in earlier
Understand.
petitions, how it will have a
I understand. So there is no bar for this court to look into it. These are
Definitely.
documents on records in respect of other cases, and you have given a compilation to Mr. Chaudhary. We may record that as I can appoint you as an amicus also. There is no difficulty.
otherwise.
So then now, I'll post this on 3rd.
Yes.
Let Mr. Gogoi file whatever he wants to.
Yes,
He
yes.
wants to submit something. 825. Mr. Majumdar, and that your motion matter. There's
Mine
no-
is already tagged, my lord. Mine is
no,
3749.
nothing has to be done there. That will remain along.
No, there, my lord, Lordship would recollect, I made a prayer
I
for.
understand, but what
Then on
I'm
3rd, it can be taken up altogether.
no, because if there also if the respondent wants to file something,
Yes,
so then I'll keep those two matters together. 2 and
Yes.
3.
yes,
2 is my matter.
2 is yours and 3 is there.
yes.
2 and 3 doesn't. 2 and 3, na? 2 is yours and 3 is Mr. Chaudhary's.
Yes.
So in both the matters, I can simply issue notice. Mr. Gogoi, in item 2 and 3, I'm issuing notice and returnable 2 weeks.
2 weeks.
2 weeks. And in 5, I'm posting it 3rd. You give whatever you have to give. After seeing that, we will decide what is to be done. In item number 2, presents to Didya, Mr. R. Majumdar for petitioner, and Mr. K. N. Chaudhary, you are for
Respondent number
senior
9 in
counsel,
his case.
assisted by
R. Kakuti.
R. Kakuti for respondent number 9. Health, Mr. Gogoi. Health is Mr. Gogoi. B. Gogoi, standing counsel, health. Respondent number 456. Mr. K. Gogoi, standing counsel, CGC. All respondents represented.
It would be 7 and 8. I think.
By way of this petition, under Article 226 of the Constitution of India, the impugned inquiry proceedings and consequential orders thereof is under challenge. Issue notice, returnable 4 weeks. 2 weeks.
2 weeks.
I'm making it 2 weeks. Mr. K. Gogoi accepts notice for R1. R1, right? Yes, all respondents have your page 4 ready.
Sonia?
Try for R1 and 2.
R1 and 2. Then 3, 4.
R1, 2, 3. R1, 2, and 3 also.
R1, 2, 3. Mr. Gogoi. Health. Mr. B. Gogoi for 4, 5, 6. Commissioner Secretary, Health.
Mr.
Gogoi, 4, 5, 6. Correct. Mr. B. Gogoi, 4, 5, 6. Yes. What about 7? There was one gentleman yesterday.
That is where there is another difficulty.
Why?
The gentleman who was appearing for the institute, in another petition, he appears for the Union of India, the institute, for the private petitioner and for
anyway,
everybody.
What to do now for 7? For 8, Mr. Yes, your name?
Respondent number 9.
Yes, your name.
R. Kakuti.
R. Kakuti accepts notice on behalf of respondent number 9. 7 and 8.
Perhaps notices has to go.
All right. Then extra copies in respect of 7 and 8 registered post AD. List after. Then I'll make it 4 weeks.
Even 2 weeks still take us to beyond holidays.
List after 2 weeks on a date to be fixed by the registry. The other one, item 3. And detag, let this matter be detached from WPC 37610 of 2024. Detach ko ho jayega? हाँ? Attach देखवा ना सिल लेगी और return नहीं किया. In this matter also, by एक बार petitioner करने दीजिए, Mr. K. N. Chaudhary and senior counsel. By way of बाकी ऊपर Mr. Majumdar नाम तो ना लगे, but তেওঁলোকৰ नाम किन लीजिए. Hard belief. कितने जनर है?
Well, in my case, on the returnable date, Lordship will consider the prayer for interim.
See, that depends on the outcome. By way of this petition under Article 226 of the Constitution of India, the petitioner is. Here you are assailing the letter dated 19/9, correct?
Yes, Miller.
Assailing the letter dated 19/9/2024 and 19/9/24, whereby the petitioner is sought to be retired, whereby the petitioner is directed to be retired at the age of 65.
No, by this, no, my lord. By this order, respondent number 5 has been appointed as in charge director.
By which the respondent number 5 has been appointed as an in charge director. So, issue notice, returnable 4 weeks, returnable 2 weeks. 1, 2, 3, K. Gogoi.
4, 5, and 6 by registered.
4, 5.
4 and 5.
5 I think. 4 and 5 registered post. Here health is not there. Not a party. After list. All right. And in item 5, it will go further list on 3 for further hearing. I'm simply keeping it for further hearing. Understanding is that you are going to hand over that. Okay. And I'm noting here that a compilation of all the relevant notifications and documents have been provided by Mr. R. Majumdar, Learned Counsel, appearing in WPC number 4975 of 2024, which was in which an identical issue, which is dependent on the outcome of the present writ petition, comma, the same is kept on record, which is not objected by the learned counsels appearing for all the contesting parties. Stop. All right, Mr. Majumdar.